Yes, it is possible to have the conditions in an undertaking or release order varied or replaced. This is actually outlined on these standard forms themselves. The undertaking, or Form 10, is typically entered into before a police officer, and in this case, the accused agrees to comply with a number of conditions and signs the undertaking in order to be released from police custody. The release order before a judge or justice of the peace, Form 11, is an order made by a judge or justice of the peace in court, and the accused signs and acknowledges the terms and conditions in court so that they can be released from custody. Often, especially when we are defending domestic assault charges, our clients come to us asking that the conditions of their release be changed or replaced. The standard conditions in these cases are usually very restrictive. They prevent any contact or communication with the person's spouse or children, and they often prevent the accused from continuing to reside at their home. There are two ways to have an undertaking or release order varied. One is with the consent of the Crown Attorney, as well as any sureties, and the other is to make an application in court to a justice of the peace or a judge. The quickest and most practical way to vary or replace a condition is to obtain the consent of the Crown Attorney. But keep in mind, this is not done automatically. The Crown Attorney is not going to vary the condition unless the accused can demonstrate a good reason why it needs to be changed. This is why hiring a lawyer familiar with domestic assault charges is important. The lawyer will know what case facts and reasons are going to be most helpful and persuasive when discussing and negotiating a variation with the Crown Attorney. And if the Crown Attorney is not agreeable to a variation or replacement of the conditions, a lawyer will then be able to recommend whether an application to the court is appropriate and likely to be successful.